Today's Converse is not driven by some deep and misplaced sense of Hindu victimhood. But we live in a country where a political party, when in power, decided to pass a law that stops communities from righting wrongs of history. Let me explain, viewers. The Places of Worship Act 1991 was passed amidst a walkout in Parliament. Specifically, the Bharatiya Janata Party walked out after opposing this legislation almost 30 years ago. That law stands in the way of communities reclaiming their places of worship that were either snatched from them or then destroyed and then built over. It makes an exception in only one case, that of the Ayodhya Ram Janambhoomi. Now, viewers, there was really no choice there, because that matter was already and thankfully pending before the courts. The case was almost 150 years old. So I had to make an exception for the Ram Janambhoomi, but froze the status of every other religious site after 1947. Now, according to Hindu groups, this law militates against them the most. And it is obvious to see why, because they have suffered the most under two waves of settler colonization. First, the Islamic invasions that started in 1000 AD and saw the new monarchs defile symbols of Hindu culture, and then, of course, the British from the early 1700s, when there was a further imposition upon our indigenous way of life. The Hindu groups want the law revoked. There are two ways of doing this, either through parliament, and given that the NDA led by the Bharatiya Janata Party is in majority and prides itself on its Hindutva outreach, this should be easy. The other option is, of course, to go through the courts, the Supreme Court to be precise, and that's where the matter is. Some Hindu groups have gone to the Supreme Court and have said persuasively that this particular law should be repealed. The left, of course, and those that oppose this move say that revoking the law will destroy the secular fabric of the country, as it will lead to the reopening of old wounds. They ask rhetorically, how many such complexes where there are mosques, etc., will be dug up to look for the remains of Hindu temples, etc.? And that's a valid concern, viewers. It's a valid concern. For now, the NDA seems to have succumbed to this logic, as neither has it brought a law and neither is it taking a clear stand in court. 6 days, court days, have come and gone, and the centre hasn't made up its mind. As the court sets another date, let's ask whether this law fails the secular test or passes it, and whether Hindu groups are justified in making a bid to reclaim their places of worship. There are two aspects to this conversation. There are two aspects to this show. So let's open this up without delay, and I want to begin first with Uday Mahurkar, an author, and Dr. Ranganathan, Vishnu Jain, the lawyer, Tehseen Poonawala, political analyst, and Sanjay Hedge, senior advocate of the Supreme Court. So let me begin by setting up this debate by first bringing in Vishnu Jain. Mr. Jain, a number of Hindu groups and lawyers have gone to the Supreme Court. Why do they feel aggrieved by what many believe is a law that is aligned to the basic feature of India's constitution? What's the problem with it?
Good evening, Rahul. See, to answer your question straight away, the basic problem in Places of Worship Act 1991, and if someone reads the provision of section 4 subclause 2, is this, that it takes away the right of judicial review, which is the basic structure of the constitution. if someone will read 5 judges judgment of the Supreme Court, it has held categorically that right to judicial review is one of the basic features of the constitution. So the basic problem which we have against the Places of Worship Act is that it takes away the right of judicial review. And let me put this entire debate in a perspective. And if we take the example of Kashi case, for example, Rahul in Kashi Vishwanath case, the first suit was filed in 1991. Till today we are in 2023. We are not out of this debate that whether this suit is barred by Places of Worship Act or not. Take an example of Mathura Shri Krishna Janmabhoomi case. The entire case is stuck and lingering so far as the aspect of Places of Worship Act is concerned. I am very grateful to you, Rahul, that you have suggested two measures to get out of the purview of Places of Worship Act. You have suggested the legislative measure, you have suggested the judicial measure. But I am also suggesting a third measure, that is judicial interpretation. I don't need much of finding from the Supreme Court. I only need this finding that this Places of Worship Act does not bar adjudication of religious character. So the word which is used under section 4 subclause 1 of the Places of Worship is that religious character can be determined, and there is a judgment also of the Supreme Court so far as this aspect is concerned. So my point is that suppose, for example, in any place there is a mosque, and if I want to say that no, it is not a mosque as per Islamic law, there was a pre-existing temple there, so the religious character has to be determined, and for determining the religious character, suit has to be filed, evidences have to be led. Evidences will include historical evidence, documentary evidence, archaeological survey of India evidence, expert evidence, and after all these things it can be decided that whether a person who is saying it's a mosque and the second person who is saying it's a temple, whether it's a mosque or a temple as per law. So Places of Worship Act and the basic argument with the Anjuman Intizamiya and basic all the masjid committees have is this, that they don't want trial into this entire matter. They are saying that no, this case can't be filed, there can be no trial. And there is where our basic problem is, and there is why we are aggrieved. We only need this interpretation so far as this legal confusion is concerned, that religious character can be determined under the purview of the Places of Worship Act. And kindly see the irony, Rahul. I want to say it with utmost sense of responsibility. The same government, Narasimha Rao government, enacted the Places of Worship Act in 1991. Within a span of 4 years, Waqf Act 1995 was enacted. Under the Places of Worship Act, you took away our right to judicial review. But under the Waqf Act 1995, you gave them the right to declare any property as Waqf property. Against that, if somebody is aggrieved, he can go and file an appeal before the Waqf tribunal, then the High Court, then the Supreme Court. So far as our rights of judicial forums are concerned, has been taken away, and to another community that same right has been given. So this is the discrimination, this is the legislative discrimination, against that we are fighting.
Okay, that's a very comprehensive opening salvo. Let me bring in Mr. Sanjay Hedge, senior advocate from the Supreme Court. Mr. Hedge, do you agree or do you disagree with Vishnu Jain? If you do disagree with him, why?
See, listen, the act was passed in a specific circumstance after the destruction of the Babri Masjid. Parliament at that point of time took a call that this one dispute we keep out, otherwise all other similar disputes we put a halt to, and that no courts will go into them. That was Parliament's call in 1991. Today the composition of Parliament has changed. If you want to change the law, it is entirely within Parliament's competence, subject of course to other questions of fundamental rights, basic structure, and all that. Now, why should courts get into political questions when the politicians are perfectly capable of answering them? You want to say that that consensus which existed in 1991 no longer exists, circumstances have changed, and we should go about allowing everybody to reopen old wounds. Fine, if that be your political case and you want to pass a law, please pass it. Because it is not only then that you will have disputes about conversions of temples into mosques or vice versa. You might very well have the Mahants who ran the Golden Temple saying, please give back the Golden Temple to us. You may very well have the Buddhists citing Swami Vivekananda who said that the Jagannath Puri temple was an old Buddhist structure and it was re-Hinduized. So we had to draw a line as a society, as a nation. In 1991, after the first of these disputes, really ended in a great deal of violence at that point of time. And those of us who were young in 91, 93 saw the kind of violence which erupted. And that was what Parliament chose. Now, if you think that you want to reopen that can of genies, let genies out of the bottle, please do so. But take a political call. Don't ask the judiciary to do your dirty work.
Well, one second. Now, last we checked, Mr. Hegre, I came to you because you're a lawyer. First of all, just a quick correction. I think you got your dates mixed up. The PWA 1991 was brought in, was notified on 11/7/1991 before the Babri Masjid demolition.
It was in the context of the Babri Masjid demolition. I stand corrected.
There was no demolition. It was in the context of the the Ram Janam Bhoomi movement, not the Babri demolition. That came much later. So let's
6th of December 1992.
Wonderful. So that came much later. So let's first of all set that aside. Now, you have answered totally from the political perspective. You have not given us a legal response to Vishnu.
I'm giving you a legal response. The legal response is that courts do not get into political questions, avoid the political thicket, let politics do its job.
Oh, come on.
At several points
courts rule on quotas all the time.
Where there are political questions, often courts say, go right back to politics, solve it politically.
Okay.
Do not bring it into the courts.
Sir, are you aware?
And there have been several instances.
Okay, so let me, on this note, I'm not going to digress. I'll stick to this point. And now I'm asking you my follow-up question before you say I interrupted you. Are you aware of the Ayodhya judgment?
I have written about it.
You've written about it. Do you know there is a paragraph in the Ayodhya judgment where, without being called to examine the justices in all their glory and wisdom, commented on this particular Places of Worship Act without any invitation, without any cause, and talked about how it is aligned to the basic structure of the Constitution? Mr. Vishnu Jain doesn't think so. That's why we are having this. So the courts have actually already commented on this issue. In fact, if they didn't want to comment on it, they should have kept quiet back then. We can't have it both ways. Mr. Hegre.
The answer is simple. The Ayodhya decision, the dispute was already before the court. In the Ayodhya decision, which you now so superciliously adverted to, they said that the demolition of the Babri Masjid was an egregious act of infamy. They gave a decree to both sides. They said that the Muslim side had proved its case, the Hindu side had proved its case. But thereafter, a matter of statesmanship under 142 of the Constitution, which allows the court special powers, they said that in terms of the decree, double the area would be given to the Muslim side, but outside that core area. So the Ayodhya judgment was a matter of judicial balancing of a case which was already before them. Here is a matter which is capable of a political solution. If you are in power and you choose not to do anything about it, and yet want the courts to do your dirty work, the courts can very well say, sorry, handle it politically.
Okay, so now I just want to point out a huge, I could drive a truck through this contradiction, viewers. So after the Ayodhya judgment came out and this unsolicited comment was made on the Places of Worship Act by the 5 great honorable justices, and they are great, and they are honorable. Viewers, the entire left ecosystem said, let's not tinker with the Places of Worship Act. They quoted in chapter and verse the words of the Supreme Court, the 2.5 paragraphs. And I wish I had all the time in the world to read it to you, viewers. Because it goes into about a page and a half of the most inscrutable English to say that the Places of Worship Act meets the constitutional test. And it is perhaps the most secular piece of legislation passed in modern Indian history. This is what the great Supreme Court justices said, viewers. And therefore, all those great tripwires and prints and squints and everything of the ecosystem took to heart was that don't touch this Place of Worship Act. The Supreme Court has already made its mind clear. Now when Vishnu Jain has applied his mind and has come out with a searing critique of the act, they say, oh, the Supreme Court should not do the dirty work of the executive. Of course, the executive, as I've already said, viewers, has lost its perspective on this issue. And I will talk a little bit about that with Mr. Uday Mahurkar.
Give me one sentence.
Yeah, take
Rahul.
two, sir.
Okay. The simple sentence is this. The Supreme Court in the Ayodhya judgment would have said that. But the Supreme Court did not tell Parliament, no, you cannot repeal that act.
My dear fellow, Mr. Hegde, I'm only talking about the fact that the Supreme Court thinks it has the right to have an opinion on a law which you think it should not have a right to have an opinion on. I'm only bringing out that contradiction. So the Supreme Court has already...
Dear Mr. Moderator,
the Supreme Court has already gone into it. It is already, by admitting this plea, it has already decided to go into the merits of it. Now, if you have a substantive legal argument to make, let's make it. Please rebut Mr. Vishnu Jain.
Listen, I don't think he made a substantial legal argument. He made an emotional argument. Okay. And you seem to be going the same way. As far as the law is concerned, the Supreme Court has said what it has said in the context of the Ayodhya dispute. Thereafter, it has not said that you cannot repeal any law or that the repealing of any law would be unconstitutional.
Okay, let's set this aside. I was hoping, I said, for a very interesting legal to and fro between the two sides. Emotional or not, whether Vishnu Jain got emotional, if he has, it should be pretty easy to contradict him in law. You could have had him for lunch. Nonetheless, let me bring in Dr. Anand Ranganathan on this. Dr. Ranganathan, we've heard an interesting sort of, I couldn't call it a face-off. It's probably with me, rather less to do with Mr. Jain. But you heard that exchange. What do you make of this? Is there really a case, number one? And most importantly, does the Hindu community legitimately have a right to seek redressal?
I don't know why the good Mr. Hegde is getting so hyper at you about, because he's right and he's wrong. Let me first say where he's wrong, in my opinion, of course, because he's an esteemed lawyer. Because for him to say that this is a political decision or something Supreme Court should get into, I think it's wrong, because a bad law, a draconian law or a bad act is as much in the domain of law as it is in the domain of politics. And the Supreme Court has been adjudicating on the size of Aloo Bonda, on Sandals, on demonetization, on Justice Loya, on Rafale, on everything down to sliced bread. And now suddenly you say Supreme Court must not adjudicate on this. So I think that's wrong. But where he's right and where he did not go to the extent that I want to go is that he did not say what I'm going to say, is that the BJP, the party and Mr. Modi are cowards. He is absolutely right. Before the Supreme Court should adjudicate on this, the party, the BJP, the ruling government, Mr. Modi should have abrogated this act. This is what he didn't say, that the BJP and Modi are cowards, and I am saying this, Behral. Now let me come to the main thrust of the things. Let me show you this tweet of yesterday. This is from the Times Now. What it shows, Rahul, is the remains of Naraneshwar Mahadev temple have been discovered underneath a dargah and a mosque in Pune yesterday. But according to this Places of Worship Act, Hindus have no right to even approach the courts to be able to reclaim this holiest of holy Naraneshwar temple, Mahadev temple in Pune. According to Dr. Mohan Bhagwat, the Hindus have no right to even look for a shivling underneath the mosque at Pune to discover their beloved temple. That is why I say that in this so-called Hindu Rashtras, Hindus have been reduced to 8th class citizens. And I'm telling this without any qualms whatsoever कि जो हिंदू है इस देश में, जिस हिंदू का दम नहीं घुटता, इस देश में वो दम नहीं लेता. That's the sad fact. Rahul, history written by the victors is peddled by the vanquished. And we remain vanquished. To me, one of the most barbaric legislations ever enacted in India is the 1991 Place of Worship Act. But in 2019, as you said correctly, the virtue signaling Supreme Court in its Ayodhya judgment willfully ratified this act that obligates maintaining all religious places as they were on August 15, 1947. So historical injustice of Kashi can now never be addressed unless Parliament overrides it. A legal recourse to correct historical injustice cannot be denied in a democracy. This is not a Hindu issue. I, as a Darwinian atheist, demand the abrogation of the Place of Worship Act. Rahul, if a mosque had been demolished by a Hindu king and a temple built on it, I, a kafir and an atheist for whom Islam sanctions death penalty, would have fought for the right of Muslims to legally take back that mosque. To me, the mark of a civilization is this unquenchable thirst to demand justice for your ancestors, to correct historical wrong. For that exemplifies a continuity, an idea, a memory that can never be erased, that is worth fighting for and preserving. It makes justice greater than the sum of its parts. And that is why civilizations are not fleeting like empires, Rahul. That is why history is a medicine. Catharsis is a cure. If an image could speak 1,000,000 words, it would be that of the Nandi waiting patiently for 400 years for his Lord to emerge and this historical injustice to be corrected. From Somnath to Kashi Vishwanath, these injustices have deliberately been made visible as though to lionize the debasement, celebrate the humiliation. And the irony is that the same people who have taught us this, drilled this self-loathing in us, these same people want others to fight historical injustice around the world. They condemn barbarians of the West either to worship like the Confederacy generals Rhodes, Churchill, Pizarro, Murray, Colston, Leopold. They celebrate their roads and buildings being renamed, their statues being brought down. But here in India, this same set eulogizes barbarians like Aurangzeb. Finally, to show you the extent of this conceit, let me actually read out to you a passage from the 2019 Ayodhya judgment where Milords exult and willfully ratify this act. Quote, the Places of Worship Act imposes a bar on the institution of fresh suits or legal proceedings. The only exception, other than Babri Masjid Ram Janambhoomi case, is in the case of suits, appeals or proceedings pending at the commencement of the law on the ground that the conversion of a place of worship had taken place after 15th August 1947. The Place of Worship Act is thus a legislative intervention which preserves non-retrogression as an essential feature of our secular values. The Places of Worship Act is intrinsically related to the obligations of a secular state. It reflects the commitment of India to the equality of all religions. Above all, this act is an affirmation of the solemn duty which was cast upon the state to preserve and protect the equality of all faiths as an essential constitutional value, a norm which has the status of being basic feature of our constitution. There is a purpose underlying the enactment of the Place of Worship Act. The law speaks to our history and to the future of the nation, unquote. I am sorry, but this law airbrushes our history and it destroys our future.
साल क्या बदला इस समय में? देखो तो बहुत कुछ और देखो तो कुछ नहीं. वही प्यार, वही स्वाद की फुहार. Celebrating 25 years of being safer with Faber.
सुशासन विकास रोजगार, डबल इंजन की सरकार. मोदी योगी की मेहनत से बदला आज नजारा है.
खुशहाली के एक्सप्रेस वे पर बढ़ता राज हमारा है.
यूपी की रफ्तार देख कर बोली दुनिया सारी. 6 वर्षों का काम दिख रहा 60 साल पर भारी.
6 वर्षों का काम दिख रहा 60 साल पर भारी.
कांप रहे अपराधी डर से, छटा घोर अंधियारा है.
खुशहाली के एक्सप्रेस वे पर बढ़ता राज हमारा है। खुशहाली के एक्सप्रेसवे पर बढ़ता राज हमारा है।
सुशासन, विकास, रोजगार, डबल इंजन की सरकार, 6 साल यूपी खुशहाल।
कैसे लहराते हुए आ रहे हैं?
2 लस्सी
जल्दी। कुछ समझा प्रमोद? नया फोन का घमंड है।
फोन नहीं, फोन में फायदे का ऐप बता रहे हैं।
टाटा मोटर्स की फिटनेस ऐप है। ट्रक के बारे में सब पता लग जाता है। माइलेज कैसे बढ़ाना है, ट्रक की तबीयत, रास्ते, पंप, ढाबा, मैकेनिक, सब है। स्मार्ट बनो। देखा प्रमोद कैसे धुआं निकल रहा है।
अब ड्राइवर की आमदनी होगी और भी ज्यादा। टाटा ट्रक्स, देश के ट्रक्स।
Let me tell you, viewers, I made it a point to read the entire debate in Parliament in 1991 when this great law was enacted, viewers, passed, when this bill was passed. What has the Supreme Court sealed shut? An idea of secularism. And in that debate, what was that idea of secularism? It was posited by an individual called Vishnu Shankar Jain, responding to Uma Bharti. And he said, do you know what Mr. Iyer said, viewers? He said that a mosque built upon a mandir is emblematic of India's secularism. What can be more secular, he said, than this? So, viewers, defacement, the subjugation of one community's symbols and the re-cementing of a new order, on top of that, is secularism. Well, viewers, by that yardstick, Spain, that went about through its conquistadors, pillaging, raping, marauding through 3 continents, should be keeper of the secular flame. Viewers, there are many others who went raping, pillaging, marauding through entire indigenous cultures, eviscerating them. Are they all the keepers of secularism? I want to bring in on this point Tehseen Poonawalla. Mr. Poonawalla, this was the Congress's argument. A mosque built upon a mandir is emblematic of India's secularism. Is this justifiable? Just a question to you.
Rahul, at the onset, I completely concur with what my dear friend Sanjay Hedge ji said. And let me tell you, while coming to your question, why Sanjay Hedge is absolutely right on the argument that courts should not be dragged into a political battle. So a little bit of history and context. There were 2 legislations, one in 1991, the POW Act, and one in 1993. The act brought in by the Congress, January 1993, to rebuild the Ram Mandir. And S.S. Bhandari, the vice president of the BJP, stands up in parliament and says that no, let these acts go to court. We will not do it. The BJP walked out of parliament when the POW Act was brought. They didn't even stand up and oppose the act. In a war, if this was a war, you fight till the last man. They walked out, thereby paving way for this law to come in. This was an understanding, a further understanding that the mosque will not be broken, for which a chief minister went to jail. Further understanding where Advani said it was the saddest day in life, and a further understanding that the Ram Mandir would not be built by parliament, it would be built by a court of law. So it is the BJP that has taken this matter continuously to court, and that is wrong. It should have been come by act of parliament. Now let's come to the POW Act. Anand said, and I quote him, this destroys our future. What destroys our future is not building schools, but going about trying to see who did what. And Rahul, let me ask you and Anand very humbly, where does this end? At what line does it end? 16th century? 15th century? 14th century? 11th century? When does this end? As Sanjay Hedge rightly said, there are claims of some temples today being Buddhist monasteries. Are we going to break them down? There will be some claims of Jain temples being Hindu temples. Are we going to break them down? Some claims of temples being mosques or mosques being temples. Where does this end? Why is this POW Act only seen as it's hurting Hindus? It could be a Jain temple, it could be a Buddhist monastery, it could be a mosque tomorrow. And therefore, Parliament in its wisdom said, 15th August 1947, when we became independent, when Jawaharlal Nehru said to wipe every tear from every eye to fight ignorance, disease and poverty, we will move beyond this. And it kept 15th August 1947 as a cutoff, except for one issue, the Ram Janmabhoomi Babri Masjid issue. What was so wrong in Parliament's wisdom? And if you think Parliament's wisdom is wrong, I completely concur with what Sanjay Hedge said. Ask the most powerful man in the universe, the Honorable Prime Minister, and the most powerful Home Minister in the universe, the Honorable Home Minister, to repeal this act. But they go to Supreme Court 6 times, and the honorable judges are asking the SG, Mr. Tushar Mehta, what is the government stand? And Mr. Tushar Mehta, with respect to him, mutters and stutters and says, this is my personal opinion, but has not put on affidavit what is the stand of this government. I'm going to ask you one question before I end. This government also said they will make temples free. They will remove government control from temples. Have they done it? You cannot run with the hare and hunt with the hound. It does not work. The BJP is this country's greatest hypocritical party, and therefore I call it the Bharatiya Jhuta party, which only wants to spread communal poison to grow. That is the only way this political party can grow, and this communal poison now must end.
Okay, well, the matter, thankfully, is before the Supreme Court, viewers, because imagine, had the government moved a bill, what would have been said? Mahurkar, first let me bring you in before we have the second round, because you waited very patiently, and I've deliberately come last to you because I know you have a very balanced view on this. Even though you're an official of the government today, in certain senses of the term, being appointed to a post, but nonetheless autonomous, I want you, and you are also a student of history who has written extensively on such issues. So I want your perspective on this. A large number of people are going to say what Tehseen Poonawala has said, or what perhaps Mr. Hegde has said, that look, let's stop excavating our past. It's only going to bring to the surface long buried resentments. Others will say that no, we cannot disenfranchise a whole community and take away or snatch away from them the right of judicial review. Where do you come in on this, Mr. Mahurkar? And also the question that is persistently asked of your government, the NDA led by the BJP, because it claims to fight for Hindu rights, etc. Why is it not, therefore, moving Parliament to do what the Congress, to undo what the Congress did?
You see, let us go into history a bit, because, all this entire exercise is to find a solution to a very, very sensitive issue facing the nation. I think we should go into history also. You see, I have said it earlier, I'll repeat it again. You see, thousands of temples, lakhs of temples were destroyed by Muslim invaders during the medieval period. The last one to do it was Tipu Sultan, if I am not wrong, of which there is a lot of evidence. Now, there is a demand for partition by the Muslim League, which it achieves in 1947. Let me tell you one thing. Let us look at the voting pattern of 1945-46 National Central Assembly and Provincial Assembly elections. Of the total votes, the voting was less, I agree. But of the total Muslim votes, 86% Muslim votes went to Muslim League, thereby clearly indicating that majority of the Muslims of that period wanted Pakistan. Nobody can deny it.
No, sir.
Now, after that, you bring a law which doesn't give back to the Hindus Ayodhya, Mathura and Kashi. So how flawed this act is, it is totally anti-Hindu act. Against thousands, I agree with people who talk with a balanced tone that we can't think of reopening all the 33,000 or 3,300 such cases, but at least 10 to 25 such places should come back to the Hindus. Why not? Therefore, this act is a very flawed act. And one more thing, let us go into the politics which the Congress played in the first 60 years of this of their rule. You see, Jinnah demanded partition on March 23, 1940, in its Lahore meet, Muslim League meet at Lahore. Now it had two parts. One, that Muslims of this country want a different nation based on their Islamic thinking, and two was how will be the Muslims who stay back in India will be treated by India. Now nobody knows about it, but since I have written a book on this subject, I can tell you. There Jinnah had demanded preferential treatment for the Muslims who stayed back in India, who would stay back in India. So Congress was all these years following the part 2 of the Muslim League resolution. The Congress's Muslim appeasement policies are rooted in part 2 of Muslim League resolution of 1940. And Congress's hands were, I would say it was God's will, you know, that Gandhiji was killed, and it was used as an opportunity by the Congress, Pandit Jawaharlal Nehru, to thrust upon this country policies which were against the interest of the majority community, hurting their religious sentiments. I again repeat, I am not saying that we should reopen all the 33,000 or 3,300 such cases. But at least 10 to 25 such places should come back to Hindus. Why not?
No, so one second.
There should be a cap on it. I agree.
Mr. Mahurkar, this...
I agree with people...
no, I just want you to very quickly clarify this. You said by God's will, Mahatma Gandhi was... I didn't understand that. What were you trying to say there?
No, God created that situation where Gandhiji was unfortunately killed by Godse.
It was not unfortunately.
It was a
planned murder, sir. With respect to you, it was a planned murder. And the first I'm very offended. It was not an unfortunate situation. It was a planned murder.
Can you let me step in there?
It was a murder. There is no doubt.
It was not.
Don't try to catch words. It was a murder, plain murder, and most condemnable act.
Yeah, so
what I'm saying is it was used.
Let's not say it's an unfortunate...
by the Congress to thrust upon this country anti-Hindu policies.
Okay, so
and Places of Worship Act is one such case.
Okay, one second. Okay, one second. So, correct me if I'm wrong, Mr. Mahurkar. You clumsily worded that. So, people who feel that you are trying to justify the assassination of Mr. Gandhi, that's not what you're trying to do.
No, not at all.
Not at all.
It was the most condemnable act.
Condemnable.
And Godse actually, now by his action, did something which is unthinkable.
Okay, so I just want to ask you, if this particular act of parliament is so egregious, why doesn't the Narendra Modi government just step in, strike it down? They have the majority. What's holding them back?
You see, Narendra Modi government has not said no. It's a sensitive issue. I think it is seized of the matter. But the judiciary can't run away. Judiciary is intervening in every matter, political matter. Here people say that this is a political issue.
So
judiciary should not intervene.
Okay, so are you saying that, Mr. Mahurkar, if the Supreme Court...
argument, you know.
Okay, one second. So are you saying if the Supreme Court... Okay, one second, just very quickly. If you're saying it's very important, if the Supreme Court says, sorry, this is not in our domain, go back to the legislature, sort it out there, you will go ahead?
I don't think it is proper. No, not at all. Supreme Court has been intervening in each and every matter and a series of political matters. The Supreme Court cannot run away from its responsibility.
No, but you passed the CAA, Article 370, etc., all went through Parliament.
First of all, this is a flawed act. Now, listen one thing. Rahul, just imagine that Muslims are given Pakistan. I have spoken about the kind of destruction which was done of temples during the medieval period. After that, Ayodhya and Kashi and Mathura don't come back to the Hindus. For Ayodhya also, we have to go to the court.
Okay, but you can make it happen. That's all I'm saying. You abrogated Article 370, like you brought in the CA, etc., other stuff. You can easily do it. You can get up tomorrow and say, okay,
given to believe that
we are repealing this.
Okay,
of the matter. One minute. No, please. I'm running out of time.
Rahul.
sir.
They have not said no.
They have said no. They have not said no. They have not said no. Okay.
It's a sensitive matter. You should give them time.
Two people had raised their hands.
And
after...
another thing, when you open this issue, listen, Rahul.
Yeah.
Then the main issue comes as to how much you should allow.
Okay.
Where I am taking a call, a stand that 10 to 25 places could be the number.
No, that doesn't work. We can't have a halfway house. No, one second.
Against thousands of temples.
Well, that can't stop. I mean, many people will say, well, we've now got the allowance, and why not? If they feel, everyone has a particular affiliation towards their place of worship, whatever, we can't deny that. Now, one second, we can't have arbitrary cutoffs. We can't say one set of temples are more important than the other. I don't think that the halfway house or whatever quarter-way house solution ain't going to work. Just one second. Mr. Mahurkar, I understand where you're going with this.
Some cap will have to be applied if the law comes.
Well, that's what I'm trying to say. That depends
some cap will have to be applied.
So that depends, of course, on the executive. And if they can take that call, well, good for them. But if they're having such a problem, scrapping an act which is so arbitrary, I don't know how they're going to impose a cap which is going to be so.
No, I want to bring one more thing, Rahul.
Yeah.
Rahul, I want to bring one more thing.
Yes, sir.
Rahul, I want to bring one more thing. Please allow me 1 minute.
Yeah, please, go ahead.
Huh? Yeah. You see, it is also a reflection on the kind of thinking which Muslims have. Are you aware that after partition, Muslims were ready to hand over all such places? Because they were aware that they have caused partition, And Maulana Maududi, the god of Wahhabis in the entire world, he said that I have no objection to Muslims being treated as second-class citizens in India, if that is the case. That is what he had said.
That doesn't absolve the government today.
In the last 70 years, there is not a single
Forget
Muslim
that doesn't absolve the government of its responsibility, therefore, to get rid of... I understand, sir. I get what you're saying. I get what you're saying. But that doesn't absolve also the government of the day to exercise its writ. Now, 1 minute. There were two hands that raised immediately. One was Mr. Hegde's and one was Dr. Ranganathan's. I have run out of time. Mr. Hegde, what was the intervention that you were planning to make? And then Dr. Ranganathan to wrap it up. Yes.
Okay, the intervention is simply this.
Yes, sir.
You said that you put to Mr. Mahurkar that you can't run an arbitrary cap.
Yeah.
So even Mr. Mahurkar says that, look, some disputes we should solve, but the rest should remain buried.
Sure.
So Parliament took a call.
Okay.
That this one dispute, let it be, the rest we will bury.
Okay.
Today, if another Parliament wants to take another call, so be it. But it should not be the courts to take that call.
Okay. Well,
that's
okay. Well, the courts have an opportunity to throw this matter out. I don't know why then they're continuing, at least from the last count of it, they've given 6 opportunities for the centre to come back to them and pronounce their stand. Dr. Ranganathan, yes, before I wrap up, please.
3-judge bench.
Quickly, very quickly, 3 point number 1 to my good friend Tehseen, when he asked me a question. I don't know whether he's aware that I already answered his question even before he asked me. I called the BJP and Mr. Modi and his party and the government as cowards to not have abrogated this act and left it to the Supreme Court. I called them cowards. So Tehseen, you're wrong there. Number 2. I have deep respect for Mr. Mahurkar, but I profoundly disagree with him, and his words are very painful when he talks about only 10, 15 or 30 temples hame chahiye, baki sare chhod do. Who is to decide? As a Hindu, he's in fact agreeing with Mr. Hegde, because he's right. Someone can say, ki why do you want even Kashi and Mathura? Bhagwan to aapke dil mein hai. Aapko wo mandir kyun chahiye? And let me tell you, the association that Hindus have with their gods is a deeply personal one. My ancestors, that Kul Devi is in Palakkad. Last year, I took my son there. He lit the same lamp as was lit by my ancestor in 1624. The same diya. That is the association. So for my son, the association he has with the Kul Devi is probably much more than the association he has with Mahadev at Kashi Vishwanath or at third point. As far as Tehseen, I myself, again, I don't know why Tehseen, for some audio problem, he could not listen to me. I said, if a Muslim is aggrieved that a mosque has been demolished or a Jain or a Buddha, I will accompany him
to seek legal intervention. How in a democracy can you demand that you cannot have a legal intervention? Tehseen, my good friend, do you know the holiest of places for Hindus, the Krishna Janamsthan? The idols were demolished, broken by Aurangzeb. He took those idols and he trampled on them. He put them, cemented them on the stairs of Babri Mosque in Agra, so that Muslims could trample over them every time they enter the mosque. You don't find that demeaning? I am astonished, Tehseen, as an atheist, as an Indian.
Just as a point of law, viewers, I don't know, I'm not a lawyer, but it does seem anomalous that the right to judicial review is being denied to all communities in this particular matter. I'm not just talking about the Hindus. I'm not being selective. This Place of Worship Act puts a cap on all communities from seeking some amount of restitution. I don't know how that works, viewers. Now, if it's in the greatest interest of secularism and during the debate, they want to tell us that cementing the construction of an abomination upon another building, an abomination only because it came about through an act of wanton bigotry, viewers, upon another building belonging to another community is emblematic of India's secularism, then God help this secularism. We can do without it. Viewers, thank you very much for watching Converse. Thank you very much.